You keep hearing that filing a claim doesn't mean going to court. But what does it actually mean? Most people have no clue what that process looks like in Maryland or how quickly it can go sideways if you miss one small deadline. Because until you understand how claims, lawsuits, and negotiations really work here, you could blow your chance at a fair settlement without ever stepping foot inside of a courtroom. This video walks you through what a Maryland claim actually is, when court becomes necessary, and how to protect your rights every step of the way. So you know when to settle, when to file, and how to build a case that gets taken seriously, even if the other side wants to drag things out. Hi, I'm attorney Bobby Zirkin. I've been an attorney in Maryland for over 25 years, a member of the Maryland House of Delegates, a member of the Maryland Senate. When people ask whether they will have to go to court, the first thing I do is to clarify what a claim actually is in Maryland. Filing a claim means you or your lawyer notify the insurance company and ask it to pay fair compensation for your losses. That usually involves the insurer for the at-fault driver, the insurer for a business, or your own insurer for what's called uninsured or underinsured motorist coverage. The claim is not a lawsuit. It is the start of a conversation guided by evidence, deadlines, and Maryland law. From day one, my team builds the proof. We gather the police report, photographs, repair estimates, medical records, and wage information. We speak with witnesses while memories are fresh. As your treatment progresses, we assemble a settlement package that explains fault, ties the medical care to the crash, and documents how the injuries have changed your work and your daily life. The stronger and clearer the package, the less likely you will ever need to see the inside of a courtroom. Adjusters understand risk. When they see clean liability or clear liability, consistent medical proof, and a credible personal story, the path to settlement without going to court is straightforward. Timing matters. Maryland sets a general 3-time limit to file a civil case called the statute of limitations. That's under the Courts and Judicial Proceedings Article 5-101. And that deadline is the backstop for every negotiation. If the insurer is evaluating the case in good faith, we continue to talk. If the clock is starting to run down or the adjuster is just refusing to value the claim fairly, we file suit to protect your rights and to maintain leverage in the case. If the defendant is a county or a city, or the state of Maryland itself, Maryland's Local or State Tort Claims Act adds extra steps. Courts and Judicial Proceedings Section 5-304 requires written notice to the local government within 1 year of the injury, and it allows a court to excuse late notice for good cause when the government is not prejudiced. Like I said, there are claims against the state of Maryland as well, and they have a similar requirement under State Government Section 12-106, which calls for written notice to the state treasurer within 1 year before suit. These notices are really important, and they are another reason to involve counsel as early as you can. Here's the practical truth. Filing a claim opens a process that is designed to encourage resolution without a trial. Most cases settle because both sides understand the uncertainty and cost of litigation. Maryland also follows what's called contributory negligence, which has been reaffirmed by the Court of Appeals in Coleman versus Soccer Association of Columbia in the year 2013. And what it means, some trials carry real risk for an injured person. That legal backdrop often motivates reasonable settlements long before a judge or jury enter the picture. When a lawsuit becomes necessary and how courts in Maryland work. There are times when a lawsuit becomes the smart move. The insurer may deny responsibility, dispute that the crash caused your injuries, argue that your treatment was unnecessary, or undervalue the actual cost of pain and disruption. In an underinsured motorist claim, your own carrier may disagree with your valuation. Filing suit puts the defense on a schedule, unlocks what's called discovery or formal discovery, and positions your case for a neutral decision if talks fail. Even then, many suits end with a settlement before any trial date, often after what are called depositions or mediation to clarify the real risk. Maryland has 2 trial courts that handle injury cases. The district court hears money claims up to its jurisdictional limit, and trials there are heard by a judge without a jury. And the circuit court handles larger cases and has jury trial. The right to a jury trial is set by Courts and Judicial Proceedings Section 4-402. From a client's perspective, district court is typically faster and less expensive, while the circuit court takes more time and often requires, in fact does require, expert testimony and additional litigation costs. The forum we choose depends on the size of your claim, the complexity of the medical proof, and the strategic goals for your case. Once a lawsuit is filed, the case moves through pleadings and discovery. Both sides exchange written questions and requests for documents. The written questions are called interrogatories. Depositions follow, where parties put witnesses under oath and they answer questions with a court reporter. Medical providers can give testimony by recorded video or in person so that a judge or jury can hear directly from that doctor. Courts commonly set mediation or settlement conferences, or both, on the scheduling order. Mediation is confidential and led by a neutral who helps both sides evaluate risk and explore resolution to the case before it goes any further. Many Maryland cases settle at this stage because each side now sees the strengths and the weaknesses that were not necessarily obvious at the beginning of mediation. If settlement does not happen, the court sets pretrial deadlines and a trial date. Motions may narrow the issues, exclude unreliable expert opinions, or resolve disputes without evidence. Throughout this phase, we keep talking with the defense because every deposition, every medical opinion, and every ruling changes the risk calculation. That constant reassessment is why so many cases settle after suit is even filed when the parties started really far apart. What trial actually looks like in Maryland. So, trials are manageable when you understand the flow. In district court, the judge acts as the fact finder. Your testimony tells the story of the crash, the pain you felt, and how your life has been affected. Maryland law streamlines proof in these cases. Courts and Judicial Proceedings Section 10-104 allows medical records and bills to be admitted without proper written certification in the district court, which keeps costs down and avoids pulling doctors away from patient care. The judge weighs credibility, applies Maryland negligence law, and makes findings on liability and damages. These trials are focused and efficient, which is one reason many modest injury cases are filed in the district court. Your costs remain down. Circuit court trials are more formal, but predictable with preparation. A jury is selected, opening statements are delivered, and witnesses testify live or by video deposition. Medical experts explain how the crash occurred and how that crash caused the injuries and why the treatment was reasonable. Economic experts can address lost wages and future costs when those are disputed. The defense presents its case, which may include competing experts. The judge instructs the jury on Maryland law, covering negligence, causation, damages, and any defenses that have been raised. The jury deliberates and returns a verdict on liability and the amount of damages. Two features of Maryland law shape strategy in the courtroom. First, contributory negligence always hangs out there, and it's an all-or-nothing defense. The state's highest court reaffirmed this rule in Coleman v. Soccer Association of Columbia in 2013. If a jury finds that the plaintiff was even slightly negligent, and that this negligence helped cause the harm, the claim is barred. That is a major reason careful investigation, consistent medical proof, and thoughtful witness preparation really matter. Second, Maryland places a statutory cap on non-economic damages in personal injury cases under Courts and Judicial Proceedings Section 11-108. The cap does not eliminate recovery, but it can limit pain and suffering awards above a certain level, which is one more reason to present a complete picture of medical losses, wage loss, and future needs. How to minimize the chance of court and protect your case. Your choices after an automobile crash can dramatically reduce the chance you will ever see a courtroom. Seek medical care promptly and follow the treatment plan. Gaps in care invite insurers to argue that you were not seriously hurt or that something else caused your symptoms. Keep a simple journal of pain levels, of missed activities, and the effect that your crash had on work. Photograph vehicles and visible injuries while evidence is still fresh. Save every bill and receipt so we can prove value rather than debate it. Provide names and contact information for witnesses as soon as you have them. These small but steady steps build the kind of file that settles cases without going to court. Be thoughtful with insurer requests. Do not give a recorded statement to the other driver's company without having gotten your lawyer involved first. That feels cooperative, but it is designed to lock you into answers before you have a full picture of your injuries. And without an attorney, you are likely to say something that will not help you later down the line. Do not sign broad medical authorizations that open your entire health history. We produce what is relevant and protect your privacy from things that are irrelevant. Be mindful of social media. Photos of travel or gym activity are often used out of context. If you are unsure whether to post something on social media, do not post it. Those habits reduce arguments that the defense can use to delay or discount your claim. Negotiation is a disciplined process. We calculate damages based on medical evidence, lost income, and the way injuries have changed your daily life. We study verdict ranges in the county where your case will be tried because value is local. We evaluate all available insurance, including uninsured and underinsured motorist benefits, and we coordinate any personal injury protection or medical payments coverage that can help with short-term bills. If a government entity is involved, we confirm that the required notices under Section 5304 or Section 12106 have been met so that your leverage is never in doubt. All of that work is aimed at one goal: a fair settlement without a courtroom. Let me leave you with a clear roadmap and an invitation. You learn that filing a claim does not automatically send you to court, that Maryland's 3-year deadline and the government notice rules keep everyone moving, and that most cases settle because discovery and mediation revealed the true risk for both sides. You actually learn what a Maryland trial actually looks like, and how rules like contributory negligence and the cap on non-economic damages shape your strategy. If you want to protect your rights in the next stage, do not miss the next video. Can I file a claim if I am partially at fault in a Maryland car wreck? It explains how fault is evaluated here and why one careless answer can end an otherwise strong case. Watch it now so you can avoid the traps and keep your options open. See you over there.